Hello everyone, welcome to Professional IAS. Today, let us see how a PM can be arrested or a cabinet minister, central cabinet minister can be arrested. This is our topic and stay tuned with me. After this, we'll also see how the CM and cabinet minister, okay, of the state will also be arrested. So let us see the procedures of arresting PM or cabinet minister. One important point that you have to remember, any person, whether it is PM or it is peon, okay, all of them are considered as ordinary person. Remember this point. Ordinary person in the eyes of law means there won't be any discrimination to me. There won't be any discrimination to the PM. There won't be any discrimination to the cabinet minister. There won't be any discrimination with you when it comes to what law. Everyone has to abide by the law, and in front of the law or act, every individual is ordinary. This is the first point that you have to remember. But you have to also see that there are some special privileges given to these people. Why? Because they are running the government, they are heading the state. That is the reason some kind of relief is given. Remember this point, I'm using the word relief is given. They are not like we are going to like we don't consider them as criminals, or we cannot file the suit. Okay, it's not like that. We cannot arrest them at all. I'm talking about we, because they are very big dignitaries and also running the government. We also need to see that whether the administration will run properly or not. Okay, whether the parliament will run properly or not. That is the reason there are some relief given to these people for a particular period of time, and that is also very restricted manner. It's not like that there is a lot of differences there, just like the inequality report of our country, where 1% of the population is holding nearly about 30% or 23% of the India's wealth. 90% of the population is holding 10%. It is not so significant. The relief is very, very minor. Let us start our discussion. Procedure of arresting prime minister or cabinet minister. Okay, let us see this. Okay, sure. I'll change the color, just wait a second. Right. So the procedure of arrest is laid down by the Home Ministry. It means what? There is no provision in our constitution which actually gives us rules or guidelines, something like that, to arrest what? PM, cabinet minister, or CM or cabinet minister of the state. So there is no rule, nothing like that mentioned in our constitution. Nor even an act is also not there. So statutory or constitutional obligations are not there at all while we are arresting PM or cabinet minister or CM or cabinet minister. This is the point that you have to remember. Every procedure with regard to the what arrest of PM or cabinet minister is laid down by Home Ministry. This point you have to remember. At this point of time, it is under the control of Amit Shah. Now the first one, criminal case and arrest warrant. If parliament is not in session, remember this point, in Lok Sabha, generally it is only not in session. Rajya Sabha is a permanent house. So you will see that these people are there for, the house is there for continuously, they will be always present. But with regard to Lok Sabha, they may be what, having breaks with regard to a winter session, budget session. So they may have a session, they may not have a session. Here two situations will come. They may have a session, they may not have a session. But Rajya Sabha, as because it is a permanent house, they are always in the session. That's why you have to properly understand what I am saying. This difference is important here. Okay, otherwise you will not understand the lecture properly. If the parliament is not in session, we are talking about what? Lok Sabha here. Okay, if the parliament is not in the session, just like today we don't have parliament running in our country, PM or cabinet minister can be arrested. Anyone can be arrested by law enforcement agencies. Law enforcement agencies are nothing but the agencies that are created in order to enforce law. In order to enforce law, like we are having CID is there, like we are having CBI is there, like we are having ED is there, Enforcement Directorate. Remember this point. So if a parliament is not in the session, PM or cabinet minister can be easily arrested by a law enforcement agency in case of criminal case registered against him. Very, very important point. So here we are not talking about civil case. We are not talking about dowry related aspect. We are not talking about land related disputes. We are not talking about succession related disputes. We are not talking about marriage related disputes. We are not talking about adoption related disputes. So keeping all of this aside, if any case is registered, criminal case is registered, PM has harassed me, this cabinet minister has harassed me, so immediately enforcement agencies can easily come and arrest. This is one point. Okay, only in what? Criminal cases properly written, please see it. Now, this is what, if the parliament is not in session, as I have told you, it is about completely Lok Sabha provision. Can be applied to the Rajya Sabha, because Rajya Sabha is always there in the session, the same will be applicable to Rajya Sabha also. Remember this point. Now, as per section 2020, section 22A of the rules of procedure and conduct of business of Rajya Sabha, whenever a police or judge or a magistrate, okay, if they are giving any warrant, if they are giving any order, if the police want to arrest, first of all, with regard to Rajya Sabha MPs, police, judge or magistrate should intimate the chairman of Rajya Sabha, nothing but our vice president. They should intimate that so and so person regarding we are issuing a arrest warrant. Judge should say that so and so person regarding we are giving a arrest warrant. Okay, police should say that so and so person is there in the Rajya Sabha MPs, we are going to detain him, like that. Remember this point. So intimate the chairman of Rajya Sabha with regard to the reason for the arrest, why they are actually arresting that Rajya Sabha MP, the place of detention, where they are going to detain him. At the house only we are going to pick up the MP who is guilty, or we are going to take him from the shopping mall, etc., so and so forth, or imprisonment in a appropriate form, or we are directly putting that MP into what? Jail. Whether detention or imprisonment of any Rajya Sabha MP, first of all, intimation should be given to Rajya Sabha chairman, nothing but our vice president. The chairman is expected to inform the Rajya Sabha council, okay, if it is sitting about the arrest. Okay, if the Rajya Sabha is sitting only to discuss about this arrest, it should be informed to the council. If the council is not sitting, if the Rajya Sabha is not sitting, what can the chairman do? The vice president can just publish it in the bulletin just to inform the other MPs. If the chairman want to have a discussion, they can put it in the council and they can discuss about the MP's guiltiness, etc., so that they can also take disciplinary action against him. Or suppose the vice president or the chairman is not at all interested in all of this, he can just publish in the notice board with regard to the MP who is for after whom the police and judge are coming, and can inform to the other members that so and so person has done something like that, and police and all may come and arrest him. This is what it is with regard to Rajya Sabha. This is completely with regard to Rajya Sabha MP. Don't forget it. Okay. Now, does Rajya Sabha or Lok Sabha enjoys any privileges? Not at all. They don't enjoy any privileges. Remember this point. But one privilege is there. In between these Rajya Sabha and Lok Sabha MPs, though they enjoy these separate privileges, no. Both of them are MPs only, treated equally. And remember this one, Prime Minister is not something who is very, very different from other minister. Prime word here is, prime word is first, means he is the first among the ministers. This is a very important point one has to understand. A lot of people does not know about it. First privileges is, say, as I have already told you that whether it is a Lok Sabha MP or Rajya Sabha MP, if they have done any criminal offence, they both can be arrested. Remember this point. Okay. But if it is civil case, which I am talking about adoption, marriage, etc. now, they have freedom from arrest 40 days before the commencement and 40 days after the conclusion of the house, whether Rajya Sabha or Lok Sabha. 40 days before the start of the Lok Sabha, Rajya Sabha, 40 days after the Lok Sabha, Rajya Sabha ended. So in this particular period, no civil cases will be registered, will be there. Cases will be registered, but no proceedings will be done in this particular period. That privilege is there both for the Lok Sabha and both for the Rajya Sabha. This provision is already inserted in section 135 of Code of Civil Procedure. Okay. Now remember this point here again, with regard to criminal offences, they are not given any kind of immunity or privilege, or cases of detention. When they want to detain a particular person also, this only for detention they can do it. Means they can stop a person to go from what? You have to be only detained after the session or before the session. You have to, don't go, you should not go anywhere, like that. So for detention purpose, for criminal offences, no freedom of arrest. Okay, remember this point. If they do any kind of criminal, then they will be arrested also, they will be detained also. Can a person be arrested from the prisons? Prisons is nothing but those people who are already sitting in the parliament, whether in the gallery, whether in the corridor, whether in the actual sitting near the speaker, whether on the benches, can a person be arrested from the precincts, we call it as, of the house? No, not at all. No arrest. Whether a member or a stranger or somebody sitting in the gallery or a media person can be made within the precinct of the house without the prior permission of the chairman or speaker. No one can directly come and pick up anyone from the what I say is that from the house, whether it is Lok Sabha or Rajya Sabha. They have to take prior permission. That to what prior? Before only they have to take permission from chairman of speaker that we want to arrest so and so person. And that too, all the rules and regulations are according to the Home Ministry given. Similarly, no legal process, civil or criminal, can be served within the precinct of the house. A legal process is nothing but, sir, you are summoned to come to the court. This summoning should also be not there in the house. Means the house is considered as completely pious, P-I-O-U-S, completely pious. No arrest of any member, no arrest of any stranger. No one can pick them up, okay, directly. No one can give a letter of summon. No one can start a proceedings or investigations on them. No one can go for interrogation. Nothing should be done on the floor of the houses, whether Lok Sabha, Rajya Sabha. Everything house के बाहर, ठीक है? And whatever they want to do, whether judge, police or whatever they want to do, they have to take the prior permission of Speaker of Lok Sabha or Chairman of Rajya Sabha. All of these are very, very important. Listen it again and again, you will understand more better. But things are almost clear to you, so make sure that you remember all of these things. Okay, fine. Now let us also see in the Financial Express, one particular news have come. Let us see that news also. Okay, you can see here. Can CBI arrest a sitting CM? Okay, so let us see the rules and regulations. Here it is properly given, my dear student, that there is whatever I explained, no, the same thing is there with the CM and cabinet minister. That is what already I have told you at the starting of the lecture only. Okay, same, because Arvind Kejriwal has been arrested. Okay, all these he was arrested on the pretext of that he is involved in Delhi excise policy case, which favored a lot of wholesalers of the liquor mafia. Okay, fine. So our intention is to go and see. Now there are only 2%, my dear students, in our country who can enjoy the immunity both from criminal and civil procedures. Only 2%. 2%, not percent, 2%. President and governor. Okay, properly it is given. The only protection from arrest, okay, is given to what? President of Republic of our country. Okay, and also to the governor, who is immune from civil and criminal proceedings. Remember this point. Who is completely immune from civil and criminal proceedings. And also according to Article 361, okay, the President of India and governors are also not answerable to any court for any act done by them in the discharge of their official duties. Remember this point. Now you see that in Tamil Nadu, Mr. Ravi, the governor of Tamil Nadu, has not administered the oath of a particular person who has been in some cases are running on him. Now Supreme Court of India, the Chief Justice of our country, Chandrachud sir, has already said that this is governor is not acting in a correct manner. Now just imagine the point here. Now it is up to what? Judiciary, but no police, nothing, no magistrate can do anything to what? President or governor. Whatever they give the decisions, whatever the actions they take, governor may not administer the oath, governor may not allow a minister to sit in the office, governor may not discuss whatever is given at a time of what? Thanksgiving, whatever is given by the governor, whatever is given by the government. So governor is completely what? He is on his own and independent. Whatever he does in his term, in his tenure, the 5 years tenure for president and governor, whatever they do inside that particular tenure, there won't be any question with regard to criminal, with regard to civil, with regard to any act done by them. The acts may result in a good consequences, the act may result in a bad consequences, that is another matter, but they will never be tried by anyone. No investigations will be proceeded against them. No court, no what I say is that no government can initiate any proceedings against the governor and president till they are in the office. They can do so only, they can do the introspection of their duties, etc., or whatever they have discharged only after they demit the house. Demit the house is nothing but when they actually, what I say is that, I just make myself bigger one so that you can, demit the house. Demit the house is nothing but when they leave the house. Remember this point. This is all about it. I hope that this is all clear to you. And make sure that you subscribe to the channel. Bye bye. Take care.